Very good morning, ladies and gentlemen. Welcome back to our next session. So our next session entitled Civil and Criminal Child Legal Aid Initiative. Ladies and gentlemen, please welcome our moderator, Mr. Nik Shahril bin Abdul Rahman, Director of Mediation, Litigation Advisory, Civil Division, Legal Aid Department, Malaysia. That is our moderator, Mr. Nik. Next, ladies and gentlemen, I'd like to invite our speakers, our esteemed speakers, to join us on stage. First and foremost, please welcome Mr. Kancio Xavier, Public Defender General of Public Defender's Office of Timor-Leste. Our next speakers, please welcome Madam Le Thi Kim Ngoy, Officer of General Administration Office, Department of Legal Dissemination, Education and Legal Aid, Ministry of Justice, Vietnam. Next, please welcome Madam Raihan Nabila binti Haji Ahmad Ghazali, Magistrate, Registrar of the Supreme Court, State Judiciary Department of Brunei Darussalam. Next, please welcome Madam Sadana Rai, Chief Representation Officer, Pro Bono SG. And last but not least, please welcome Madam Shahrina Abdul Salam, Deputy Director of Legal Aid Bureau, Singapore. Right, dear ladies and gentlemen, our speakers and moderator for Civil and Criminal Child Legal Aid Initiative. With that, I pass our next session to our moderator, Mr. Nik Shahril bin Nik Abdul Rahman. Over to you, Mr. Nik.
Thank you, Mr. Bob, as the exceptional MC. Good morning, delegates, ladies and gentlemen. It is my great honor to welcome you back from an invigorating coffee break, I trust, to this important session of the Asean Comventian Legal Aid for Children, focusing on civil and criminal child legal aid initiatives. As we know, children are among the most vulnerable in our societies. Ensuring that they have access to justice, whether in civil or criminal matters, is not only a legal responsibility, but also a moral one. There is a well-known saying, it takes a village to raise a children. In the context of justice, this reminds us that the protection of children cannot rest on one institution alone. It requires the collective effort of governments, the judiciary, lawyers, civil society, and the community as a whole. We are fortunate today to have a distinguished panel of speakers with us. Allow me to introduce them. Madam Shahrina Abdul Salam, the Director for Legal Representation and Advisory Team and Deputy Director of Legal Aid from the Legal Aid Bureau, Ministry of Law, Singapore. Madam Shahrina graduated with LLB Honours from the National University of Singapore in 2001. She joined the Singapore Legal Service upon graduation. She served first as Assistant Director of the Legal Aid Bureau, Ministry of Law. She was appointed State Counsel and subsequently Deputy Senior State Counsel, serving in the Legislation Division of the Attorney General's Chambers of Singapore. In 2015, she was appointed Deputy Registrar of the Shariah Court of Singapore and subsequently promoted to the Registrar and concurrently ad hoc President of the Shariah Court of Singapore. She returned to the Legal Aid Bureau in 2022 as the Director 1 of the Legal Representation and Advisory Team and Deputy Director of Legal Aid. Now, the format. I would like to invite Madam Shahrina to give her speech, and all speakers will be given 15 minutes to present. A first bell will sound at 10 minutes or as indicated in the screen. And a second one will indicate that you have 1 minute to conclude. Without further ado, let us give a warm applause to Madam Sharina.
Bộ trang còn hàng quá toàn hàng bị hiệp
Bỏ lon lon chụp lại.
toàn bị quá mẹ điếu thay môi
嘛是知啊，你伫法律援助你是退声上大的申请者啊，你看。所以 Madam Liu， 一阵哦，你来越南政府律师樓嗬，安怎你愛來找越南幫助你咧？
發證時咋我成就嘅求我累啊，咪求我等我多落人意，咪求我等，咪求我等求我累這樣有請律師，
想帶你去找越南？
我這個走去嘅。
哦。
我唔知影會曉福建話，我去到伊人甲我講，我袂曉聽，我就愛聽福建，伊人就去找福建甲我講話。
哦。
逐擺真好，逐擺找人，我袂曉話，逐擺找唐人會曉講唐人話來甲我講話，真好。律師樓真好，真有心，真夠照顧我，會幫忙我買念料，伊真貴嘛，迄狗伊真貴嘛。我爬袂起，伊人帶我去，伊人帶我落。伊發單，我就愛爬個狗椅去坐，嘛是真濟律師扶我去。我落嘛是伊人帶我落，不伊發單嘛知影，法官有看，法官分歡喜。
啊是伊今日有來，你愛甲伊講什麼物件？
我給他感謝咯，幫助我咯，是伊幫助我的。無我幫助我媽媽有通好笑累，伊定係叫我去問咧，逐擺去紅燈迄度問，逐擺問我嘅代志。迄陣定係幫助我，有迄陣，是無去幫鬥骹手嘛，有認為去法庭，去法官，攏總律師歡喜，我就歡喜。迄搭真濟律師，嘛甲我歡喜，當我 very good，very good，伊當 very good，真濟律師來甲我。very good，真濟律師，迄陣真濟律師。
政府律師樓哦，就是愛守護新加坡嘅公民甲 PR 鬥骹手做伊人嘅民事嘅法庭嘅代志啦。頂擺你來找越南甲你討這個錢是對嘅，我甲你講你看。
A very good morning, Datuk Nur Azmi, distinguished guests, ladies and gentlemen. My name is Sharina, and I wanted to show you the video because Madam Liu is one of Singapore Legal Aid Bureau most inspiring clients. At 103 years old, she's still fighting for her rights. The Singapore Legal Aid Bureau provides free or low-cost legal services for the bottom 25% of our population by household income. We handle various civil matters like Madam Liu's case, but about half of our cases are family law cases, most involving children. We handle about 1,200 to 2,000 divorce cases a year across the civil courts as well as the Sharia courts. In addition, we also handle cases such as child guardianship, child maintenance, as well as adoption. I will begin by sharing first on how the Singapore courts and the Singapore Legal Aid Bureau adopt a therapeutic justice to our work in resolving family disputes involving children. What you see on the screen is a logo and tagline from the Singapore Justice Courts. They champion therapeutic justice, as does the Sharia Court of Singapore. So what is therapeutic justice? The idea of therapeutic justice encompasses many things, but one key principle about therapeutic justice is the recognition that the legal process impacts the emotional and psychological being of the people involved in the legal system. And the legal process ought to do its best to minimize trauma and maximize healing for people who are having to deal with the court proceedings, especially children. The idea is to solve problems and not to find fault. As one of our appellate judges said, applications for custody, care, and access should not become tools to control the other spouse or to hurt that spouse. It is an area that divorcing parents must be responsible for. If they make the commitment and sacrifices, their children can be protected from the negative effects of a marital breakdown. Children can do well and emerge resilient and well-adjusted. Therefore, it's not about parental rights for the children, but about parental responsibility for the children. There are a suite of tools at the family justice courts to help parents fulfill parental responsibility. That is, to help them to come to amicable arrangements regarding their children, to help them build good relationships with their children, and to help the children themselves process the divorce proceedings. For therapeutic services, which are to help the parties and the children cope with the court proceedings, the court has a counseling and psychological services unit. This is a unit comprising of professionals who provide counseling services to help parties and their children cope with the emotional issues during court proceedings. The court can also tap on external agencies to give parties longer-term counseling sessions and help them with supervised access or transfer arrangements. The panel of therapeutic specialists is a panel of mental health professionals. The court or the parties can tap on them if they need the appropriate mental health support. For forensic services, which are to help the court make the best decision in any particular case, there is the Child Representative Scheme, where a trained lawyer is appointed to represent the child's best interests in court. The court can also order custody evaluation reports on the child or the family. And the court can interview the child directly, and this is often done with older children. After orders are made, the court can appoint a parenting coordinator. The coordinator will help the parent work out access arrangements without having to go back to court. Here are even more programs and tools for resolving child disputes that I would like to share with you. The Mandatory Co-Parenting Program is a program that is mandatory and provided for in the law. All parents with children below 21 must first attend and complete this course before they can file a divorce application. This is to help them understand the impact of divorce on their children. The Children of Divorce Intervention Program, which is a preventive program targeted at children aged 7 to 12 to help reduce the expected stress of parental divorce for children. There is the Children in Between program, which is separate workshops for parents and children, and targeted especially for parents who face parenting conflict when they cannot work out the matters with their spouse, or children who may already be facing or exhibiting emotional or behavioral issues as a result of the divorce. Last but not least, the Family Assist is an online resource portal. This is for those who are facing strains in the marriage but are open to strengthening the marriage, or they may be contemplating divorce, or they may have already decided to proceed with divorce. But we at the Singapore Legal Aid Bureau believe that the best outcome is if the parties do not have to go to court at all. So we practice therapeutic justice to try and settle the disputes amicably first before filing any court application. So let me share with you one story about how we did this. Our client is Madam L. She divorced in 2023, and we helped her get the care and control of her 9-year-old son. But she came back just recently and said, let my ex-husband take care of him, I cannot manage anymore. So she was actually a very stressed out parent. Whenever she tried to discipline the boy, he complained to his father. And every time he complained to his father, the father would call the police and the ambulance, and this was several times a week. So the mother denied that she was abusing the child, that she was disciplining him, but she was clearly worn down by what was happening from the ex-husband. We did not file a court application immediately. Instead, we convinced her to try family counseling and work with social workers on how to discipline her son, and this proved transformational. When she used to scold her son whenever he threw a tantrum, now she would calm him down, wait first, before she talks to him. So it's more amenable now, and he stopped calling his father at the drop of a hat. We also reached out to the lawyer of the father to get the lawyer to persuade his client to attend counseling as well, and not to call the police unnecessarily. He has since stopped doing so. So what we have done is to settle the case without having to go to court, saving the parties' time and anguish, saving our own time, saving the court's time as well. This case and many others like it inspired us to create a program called the Building Bridges Program in partnership with a voluntary welfare organization called the Montfort Care. We refer our clients to their co-parenting facilitation program where they will attend mediation and counseling before we consider if there is a need for legal proceedings. This program was started in 2023, and since then we've had 19 referrals involving custody, care and control, access, guardianship, as well as child maintenance issues. Where the parties have come to an agreement, the lawyers come in to help to formalize the agreement into a court order, which we file and have it approved by the court. A success story from Building Bridges program is Mr. B, a divorced father, in debt, 41 years old, facing job insecurity and no access to his children. He came to us because he said he cannot pay the maintenance of $3,000 per month. But if he doesn't pay, his wife would not let him see the children. So we called the ex-wife up, and the ex-wife said, well, if he can't pay, he doesn't deserve to see the children. But here at the heart is the child's best interest. Fortunately, they were both open for communication and counseling. They attended the program. And after various rounds of consultations, they agreed on a change care arrangement with a flexible maintenance arrangement. It all worked out because essentially what came out of that was that the children themselves felt more comfortable with the parents. They had a better routine that they were happy with. Even prior to the Building Bridges program, we had established our Social and Family Assistance Referral Scheme in 2016. This program is for clients whom we identified to have physical or mental health challenges, who may be living in unsafe family environments. We also work closely with the Child Protective Service under the Ministry of Social and Family Development, alongside a whole network of family service centres who service residents in their geographical area who require social or financial assistance. To date, we have referred nearly 600 clients for their assistance, and it can range from housing matters or children's education. So these partnerships are essential because legal help alone is not enough. One example is Madam K. Madam K is an aunt to a boy named J, an 8-year-old boy, who's been living with her for most of his life. One day, the parent of J came back and said, I want to take you back. J, of course, said no. He said that when he was living with them, his father had abused him. So we helped Madam K to defend the custody application filed by the mother and take our own application for custody for the child. At the same time, we referred the case to Child Protective Service and to PAVE to check whether the abuse was truly as it happened. Fortunately, it was not, but they recommended that contact between child and parent ought to be managed. So the court granted supervised visitation rights, and child J continued to live with Madam K. PAVE is actually an agency which provides integrated service for family violence and child protection. So as you can see, we have had good results when we work for fellow professionals in the social services sector. In order for the court process to maximize healing and minimize trauma, the people in the family law field must work together. In order to deepen relationships, what Legal Aid Bureau has done is to initiate what is called the Lawyer Social Worker Mixer Session. What is this? It is really very simple how we did it. We got the lawyers and non-lawyers in one room to sit at the table and to talk about case studies involving custody disputes and quarreling parents. So the professionals went about sharing their own perspectives. The social workers and counselors said that this is how you navigate a parental conflict without having the children triangulated between them. The lawyers told them, this is the court process, do not be mystified by it. And then the police, when we added them into the discussion, gave us inputs on how we can help to de-escalate conflict before it becomes criminal behavior. They found the session very enriching simply because they were able to hear the perspective of other professionals working in the same area. We intend to make this an annual event to advance the goals of therapeutic justice in Singapore. In conclusion, therapeutic justice in actions means early intervention before court proceedings to try and settle the dispute amicably, holistic support beyond legal help for non-legal problems, and professional collaboration across disciplines. It is often slower and more effortful to do all of these things rather than for lawyers to just focus on the legal issues, but we believe this is the best approach for the parties and especially their children. This concludes my presentation. Thank you very much for your attention.
Thank you very much, Madam Sharina, for those invaluable insights on Singapore's therapeutic approach to child legal aid. And she completed her speech within time, typical of Singapore's efficiency. Another round of applause. Next, we will hear from another representative from Singapore, Ms. Sadana Rai. Allow me to give a brief introduction first. Sadana is currently overseeing Pro Bono SG's legal practice as the Chief Representation Officer. She oversees the administration of community legal services. She leads a team of litigation support specialists and community lawyers, ensuring timely and fair assistance to deserving applicants through legal guidance and representation. Additionally, Sadana maintains an active practicing certificate and continues to advocate for clients in court under Pro Bono SG's various schemes. Before her tenure at Pro Bono SG, Sadana practiced commercial litigation at Drew & Napier LLC under the mentorship of Mr. Davinder Singh, Senior Counsel. She joined the pioneer batch of CLAS Fellows in 2015 and became one of the first CLAS advocates in 2017. Her dedication to public service earned her a spot in the National Council of Social Services 40 Under 40 program in 2022, a prestigious initiative aimed at fostering young leaders in the social service sector. In 2023, she was awarded the Joseph Greenberg Outstanding Youth Advocate Award, which honors young lawyers for their professional excellence, community service, and ethical standards. She was conferred the Excellence Award at the 2025 Social Service Professional Awards in recognition of her unwavering commitment to the sector. Beyond her Pro Bono SG career, Sadana is the co-vice chairperson of the Law Society of Singapore's Advocacy Committee, where she contributes to the training and development of advocacy skills for members of the bar. She is also passionate about environmental and animal welfare issues, serving on the management committee of the Society for the Prevention of Cruelty to Animals since November 2022. Wow, that's quite a list. Now, without further ado, Sadana, the floor is yours.
Should be okay, thank you. Selamat pagi, everyone. Thank you for being here after the exciting night we had last night with the dancing, you know. Ha, Asia! That was one of the best nights I think I've had in a while. I think we have a video. I don't know if the video is going to be played, but if it's not, we can start with the presentation. I will say it's very stressful to come after Madam Sharina because I'm now told that I need to keep to that Singaporean level of efficiency. Whenever I come to Malaysia, I'm always very happy because I think I can, lepak a bit, but now it seems I need to get going with my presentation. Okay, so let's start. Well, good morning, because, at Pro Bono SG, what we try and do is we work together with our friends from the Legal Aid Bureau, we work together with the Public Defender's Office. What is Pro Bono SG? So on the next slide, we show you, this is who we are. We have a team strength of about 52 people. We're a charity, actually. We're not really a national legal aid scheme. We don't work with the government in the sense that we deliver services as the government, but we deliver services with the support of the government. So we work alongside the national legal aid schemes, our Public Defender's Office, our Legal Aid Bureau, to co-deliver legal aid and fill in the gaps where there are gaps. So you must be asking yourselves, what are the gaps that tend to exist in Singapore where you have what sometimes seems to be a very well-run state with well-oiled machinery, so to speak. The gaps exist where people don't qualify for legal aid. So you have foreigners, for example, who may not be covered under our national legal aid schemes. And you also have people who fall through the cracks, people who may not pass what we call a means test, because all applicants for legal aid are means tested. And if they do not meet those criteria, they then may not get legal assistance through our national legal aid schemes, and that's where we come in as Pro Bono SG. Our services are three-tiered, but before I go there, this is our vision and our mission, and I thought it'd be important to highlight this because this shapes and guides everything that we do at Pro Bono SG, including the schemes that we administer for the youth. If we go on to the next page, our services are tiered in three ways. First, we look at providing awareness, and you'll see that that's the widest sort of bucket of services that we provide. It's about empowering and educating people who come to us and providing the services for free, usually. Then we provide advice through legal clinics, and legal clinics that are run in conjunction with the community as well. And we also then provide advocacy services, which are our in-house lawyers and our volunteer lawyers who are practitioners from the bar, volunteering their time to provide services to people who need them and who pass a means test as well. Moving on to the next slide. These are our numbers. In total, we've assisted 16,765 people through all of our schemes. You will see that the representation scheme appears to be the lowest among all, but that's also because we work alongside the National Legal Aid Scheme. So the numbers that both the Public Defender's Office and Madam Sharina have spoken about, these are in addition to those numbers as well. If I could move on to the next slide. Okay, so we have many offices in Singapore, and if any of you have time, please reach out to either myself or my colleague Prem, and if you ever visit Singapore, we will not fight about who has the best nasi lemak or chicken rice. We will just bring you to our centers and show you what we have done in our centers, which include a community law center at the Tian Te Temple. This is a community law center offering legal services that is located within a temple. The idea is to make these services much better and easier to access because people do not have to travel to the state courts to see us, to receive advice from lawyers. This is not a novel concept. It's not something that we came up with. In fact, in our visit last year to the Jabatan Bantuan Guaman in Putrajaya, we met with Dato' Azmi and his amazing team, and they showed us the very nice van outside that is used to go around to different areas, especially the areas that are hard to reach. And that really is the concept behind why we started installing community law centers in different parts of our country. It's very similar concepts because we thought that if the service user cannot come to us, we will come to you. And so setting up in these areas like neighborhoods, for example, and in temples where people go to pray for help and receive help has been very inspiring for a lot of service users who come to us and say, thank you for bringing this closer and for giving us legal help without it being intimidating. The temple is not the only place that we've set up our community law center. We've also run clinics in mosques, for example. We have another center at a TCM clinic where people go to get help for some of their issues. They go and get some Chinese herbal treatment. And after they get treated for that, they come and ask us, hey, can I sue this person for causing me harm? So it's an all-in-one service station where they can get help across the board. And the idea behind it is really to remove barriers and make access a lot easier for everyone. We also have legal clinics in every CDC. Singapore is not as big as Malaysia, but we have enough land area for people to need to have clinics in their respective neighborhoods so that they can get easier access. Okay, I will move on to the next slide because I only have 10 minutes left, and I just wanted to talk very quickly about our schemes and what we do. There are 4 schemes that we provide assistance through, and I thought it'd be good to talk about how these schemes help the youth and children who enter the system, because that is the topic that we have at hand today. And so under our ad hoc pro bono scheme, we provide assistance for persons who do not meet the criteria for existing legal aid schemes, meaning if you fail the LAB means test or merits test, if you fail the PDO means or merits test, which are your national legal aid schemes forms of assistance, sometimes these individuals come to us to say they have these exceptional circumstances, especially when they are minors. In Singapore, the age of majority is 21 and above, so if you're below 21, sometimes you need a parent or guardian to help you make these applications, and sometimes these individuals struggle. So they come to us to ask us for help, and we either provide them assistance through our ad hoc pro bono scheme, or we help to connect them back to the national legal aid schemes and write letters to express why their situation is exceptional, and that sometimes is successful in getting them assistance through the national legal aid schemes. We also provide assistance through the criminal legal aid scheme, which provides pro bono criminal defense for individuals who are going through the criminal legal system. How this is done: the state administers a criminal legal aid scheme called the Public Defender's Office for Singaporeans and permanent residents. Out of that proportion of cases, they assign us 40% for us to take on, and we take on all the foreigner cases that come through our doors. These include cases involving minors, so involving people under 21. The idea behind providing legal aid to those under 21 as well is an acknowledgement that they cannot represent themselves in court because they may not know enough about how to defend themselves, and it's important to have a lawyer to come on board to do this. I wanted to talk about 2 cases with very different outcomes and what we have done to bridge those gaps for these individuals. So I'm a criminal defense lawyer by practice, so I do take up cases myself. And the outcomes for young people in Singapore can be very different depending on their personal circumstances. In Singapore, we have, and I'm absolutely certain this is also the case in Malaysia as well, we have probation for young offenders where they are allowed to rehabilitate in society, and that is primarily because the emphasis has been placed on rehabilitation as opposed to deterrence for the youth. There is another option apart from probation, and that's called reformative training. And reformative training is a more advanced form of rehabilitation in which the individual, the youth offender, is placed in what's similar or akin to prison, but it's for children, juvenile detention centers. And these reformative training centers, they are there for about 6 months or 12 months, and they are made to go through certain drills, they are made to reform through certain practices as well. It's far more intensive, it removes them from their parents. Some of them are not happy with that, and they often ask us to ask for probation. You will hear more about this in the Public Defender Office's presentation as well, so I'm not going to steal his thunder. But I thought it's good to explain to you these 2 concepts because this is going to shape the story I'm going to tell you in a bit. I was assigned to represent 2 youth offenders. Both of them were 18 years of age. Both of them faced quite similar circumstances in that they're being charged for offenses. One offender was being charged for stealing a motorbike and riding it around, going for a joyride, even went on the expressway without a helmet, very brave. This is the concept of live fast, die young, or something like that, but I think he survived it and was arrested. The other individual was made to act as a lookout during a theft in dwelling. So his friends had broken into a store, gone in to steal. He was standing outside. Unfortunately, the lot of them got caught, and both of them were charged. It's an irony that I was made to represent both of them, but it was great because it also showed me how the system can help and also not help two individuals with very different background circumstances. In regards to the individual who was on the motorcycle, let's just call him Mr. Harley Davidson. Mr. Harley was very rash. When he spoke to me, he was arrogant. His mother accompanied him for every single meeting, and he was quite confident he would get probation. His mother was very supportive. She wanted to sign him up for courses. She wanted to put him back in school. And she was very successful in doing that. She spoke to a lot of different partners, community partners as well, got letters for him, and she was extremely involved in his rehabilitation. Nice boy, a bit cocky, but, I thought that he had a good chance of rehabilitation as well. Mr. Lookout, who was outside the shop, on the other hand, did not have family that he could count on. His father was in prison. The mother had 6 other children to take care of, and she absolutely refused to bail him out of remand. So he was in remand. He was one of the most polite boys I had met in my 10 years of doing public defense. So he was kind, would greet me every morning. When I saw him, would be extremely kind and polite to me and ask me if I'd taken my breakfast, especially since I was rushing to see him. So you can imagine, I thought, I would love for this boy to be my son, right? And he didn't have the kind of family support that he needed to get probation. As much as I tried, the first question that was asked of me was, does he have that family support that he needs in order for him to reform himself successfully in the community? Outcomes, as you can tell, were very different. One boy got probation, the other got reformative training. I don't know if Mr. Harley, while on probation, rode again, but he's out there now, being a menace to the roads, while my Mr. Lookout probably has been released, but is probably struggling again within the community. And that's the reason why Pro Bono SG was established as well, or rather established its community law centers as well. We recognize that we are at an important intersection between the community and legal services, and we play an important role in connecting people, connecting social workers, connecting the community workers that help to provide holistic support for young people caught in the system. This means we provide the connectors, we connect them with psychiatrists, we connect them with psychologists, for example, and it's important for us to also connect them with social workers who can support them with food, with travel money, for example, with understanding the courses that they can sign up for to holistically rehabilitate themselves. We also provide support through the Family Justice Support Scheme. And the Family Justice Support Scheme is intended to provide support for families who are coming to Singapore, not just in divorce cases, but also for foreigner children who get married into Singapore families and are also now looking for citizenship and for other forms of support. We've assisted a foreigner family, for example, mother and child are Vietnamese, came to Singapore when the child was young, at 7 years of age, married into a Singaporean family, and the child was adopted by the father but was struggling to get citizenship. Pro Bono SG assisted them to get that, to create a more stable family unit for the child to grow up in. If I could go on to the next slide, please. So a big part of what we do, and I notice I only have 1 minute and 38 seconds left. But a big part of what we do is we try and educate the youth because education and knowledge is empowerment. So we have what we call youth legal clinics, where they come to us, they talk to a relatively young-ish lawyer who can identify some of their struggles and can speak their lingo and advise them what to do. For example, if they're looking for emancipation or if they're being abused by a family member and need to understand what happens if they report it. Allowing these kind of private and safe spaces for them to grow is quite important because the knowledge and empowering them and creating strong people would lead to a better community at large. And I think the one thing that often strikes me, or the quote that often strikes me, is it's easier to build strong children than to repair broken men. And so if we support them at a younger age, give them that mental fortitude by empowering them with knowledge, we build better communities in the long run and hopefully break intergenerational cycles of violence, poverty, etc. If I could just move on quickly to the next slide. So another thing we do is Project Schools, where we go into the schools to help young students, and this can range from primary school, so they are 7 to 12 years old, secondary school from 12 to 16 or 17, and even sometimes in polytechnics where we go and teach them about the law and teach them what their rights are. You'd be surprised to know that when we go and talk about certain sensitive topics, students have come forward to say, this is happening to me. I am the victim of something. Can you please help us? And so these conversations are not just important to empower them with knowledge, but also to give them an avenue and a window to reach out to us to tell us something is going on. I am out of time. If I could just quickly go through the next slide, and I think I can stop immediately after that. Maybe on the next one, because I've spoken about this already. So very quickly, just in relation to the type of protection that's also available for minors, in Singapore, youths who are going through court proceedings and who are victims giving evidence do get certain protection as well from the state and from the courts. This is in the form of shielding measures, for example. When they come to court, the prosecution can ask for a shield to be put up such that the victim does not have to face their accuser, which then makes the giving of evidence and the access to justice a lot more comfortable. What we do at Pro Bono SG is we provide assistance in the form of counseling for some of these people who are coming to us. They come and ask us what are the potential outcomes, and we provide support for them. We do not go to court with them. That is another organization's responsibility. I know in Malaysia, the Legal Aid Bureau does provide some of those kind of services, but in Singapore, we are not the ones to provide that. I am out of time, so I have a lot more to talk about. Please reach out to us and my colleague Prem, who's sitting in the audience as well, if you have more questions. Thank you.
Thank you, Ms. Sadana, for sharing those important perspectives on community-driven support for child legal aid. In the spirit of our love for food, especially nasi lemak, we don't mind to hear more. But to be fair to other speakers, let us continue. Next, I would like to introduce you our third speaker, Ms. Raihan Nabila binti Haji Ahmad Ghazali. Allow me to give a brief introduction. Raihan Ghazali is a registrar of the Supreme Court and a magistrate of the subordinate courts of Brunei Darussalam. She also holds concurrent appointments as Deputy Official Receiver in the Official Receiver's Chambers and Deputy Probate Officer at the Probate Office, reflecting the breadth of her responsibilities across the civil, insolvency, and probate landscape. Before her appointment as a judicial officer, Raihan served as a Deputy Public Prosecutor at the Attorney General's Chambers of Brunei for 8 years, where she handled a wide range of criminal prosecutions and gained extensive courtroom experience. Raihan was called to the Bar of England and Wales, Lincoln's Inn, in 2016. Raihan, please.
Thank you for the introduction, Mr. Nick Sharrell. Before I begin, I would like to apologize. I might sound a bit rough and I keep coughing on stage. My colleague and I who are here are just a little bit under the weather, but we're still happy to be here and the show must go on. Bismillahirrahmanirrahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning, distinguished delegates, ladies and gentlemen. It is a privilege to speak today at the Asean Convention on Legal Aid for Children 2025 on the topic Protecting Child Defendants in Brunei Darussalam, Legal Provisions and Pathways Forward. This subject is not only legally significant, but also deeply human. At its core, it asks, how do we as a justice system treat children who come into conflict with the law? Do we see them merely as offenders, or do we also recognize them as vulnerable individuals whose welfare, rights, and futures remain our responsibility? Before I move further along in my presentation, I think it's important to highlight the main difference between my presentation and the preceding presentations from Madam Sharina and Madam Sadana. Brunei is a much smaller country, as I'm sure we're all aware here, so our legal aid system does operate at a much smaller scale. We don't have a separate legal aid bureau or a legal aid office, and we don't have a public defender system at present. However, all is not lost, and my job today speaking here at the podium is to share with you the other initiatives that we do have to provide legal aid and support to children in the legal landscape. Can I have the next slide, please? In Brunei Darussalam, legal aid for defendants is governed by the Legal Aid Committee. It is chaired by the Chief Magistrate, and its members include judges, registrars, magistrates, and officers and staff of the Supreme Court. Its scope is limited to capital offences, and eligibility is determined by a means test only, where the committee reviews the disposable income and assets of the applicant and family. Next slide, please. What's important to note is age is not a factor of consideration. So what this technically means is that a child could be entitled to legal aid if he passes the means test. But in practice, we've not yet had any cases where a child is afforded legal aid simply because we've not had any children charged with capital offenses. Next slide, please. Legal aid is only one dimension of protection. In Brunei, the Children and Young Persons Act, CYPA, is the cornerstone of our child protection framework. The Act emphasizes welfare and procedural fairness, a child-centered approach, strong reliance on parental guardianship and institutional support. The key agencies working under this framework include the Juvenile Court, the Action Team on Child Protection, the Department of Community Development, the Royal Brunei Police Force, particularly the Women and Children Abuse Investigation Unit, and the Attorney General's Chambers. Together, all these agencies seek to balance accountability with care. Next slide, please. Can I have the next slide, please? So our juvenile court operates with unique safeguards. By law, the magistrate is required to sit with 2 advisors nominated by the Chief Justice before determining the sentence to be imposed against a child defendant. Next, please. Crucially, the law also mandates that offenses must be explained to the child in simple language appropriate to their age and understanding. This is a fundamental step in ensuring that justice is not only done, but seen to be done in a way that respects the developmental stage of the child. Further, the court must always have regard to the child's welfare, taking steps where necessary to remove them from harmful environments and secure their education and training. Next slide, please. Another defining feature of Brunei's framework is the recognition of the involvement of parents and guardians. The law requires a child's guardian to attend court proceedings unless the court orders otherwise. The court even has the power to compel or excuse a guardian's attendance if it is in the best interest of the child. Next slide, please. Next slide. And if a child is not legally represented, the juvenile court allows the guardian or another responsible person to assist in conducting the defense. And where this is not possible, the court itself will intervene by asking questions on behalf of the child, clarifying evidence, and ensuring that the child fully understands the case against them. Next slide. Now we have a flow chart here of essentially what the preceding provisions are distilled down to. We have the guardian or relative to assist the child in conducting the defense. If the child is not legally represented or assisted, which is often the case, the child can make assertions instead of questions during cross-examination. The court may put questions to the witness on the child's behalf. The court may ask the child to clarify. And if prima facie case is made, the court is to explain to the child the substance, the evidence, and all the other things that the child should understand to move forward with the case. And the child shall be allowed to give evidence. Next slide, please. Beyond the courtroom, Brunei has implemented several other initiatives. The Ministry of Culture, Youth and Sports oversees child welfare programs and coordinates implementation of the Convention on the Rights of the Child. The Department of Community Development, which is under the Ministry of Culture, Youth and Sports, runs awareness campaigns and partners with NGOs like the Brunei Council on Social Welfare, MKM. We also have legislations such as the Trafficking and Smuggling of Persons Order, which aims to protect children from exploitation and trafficking. Our judicial officers in our courts have also benefited from training and exposure to youth justice systems in countries such as Singapore and New Zealand, which aims to strengthen our child-sensitive approach. On the regional front, Brunei has participated in ASEAN frameworks, and just recently, at the 9th CACJ meeting in 2021, which Brunei was also a party to, the CACJ acknowledged the adoption of 2 documents. First, the enhanced common procedure for dealing with cases where there is a cross-border dispute involving children within ASEAN. And secondly, a non-binding code of ethics for mediators encompassing the aspired values and minimum standards for mediating cross-border disputes involving children within ASEAN, shortened as the Code of Ethics for Mediators. Next slide, please. Our challenges. Now, despite all these efforts, we must also acknowledge that there are challenges, mainly the legal aid limitations. With legal aid restricted to capital offenses only, most child defendants in criminal matters receive no formal assistance. 2, manpower constraints. As I've highlighted, we are a smaller country, so we do have a smaller pool of legal professionals. We have a limited number of counsels available through the Legal Aid Committee, and even fewer with experience in criminal trials. And we require specialized training in handling child witnesses, which remains a pressing need. Thirdly, public awareness. Many families are not yet aware of the legal supports available or how to access it. This creates gaps in protection, even where the law provides avenues for support. Next slide, please. Encouragingly, we do have other preventive measures, and we have helplines that provide immediate assistance. Agencies such as the ones you can see on the screen, the top is the Royal Brunei Police Force, and at the bottom, I believe it's an officer from our prisons department. So these types of agencies regularly go out to the schools and they conduct talks on pressing topics concerning children in criminal justice. So the 2 that you can see here focus on cyberbullying, which has sort of been on the rise in Brunei, although they don't tend to end up being charged in court. It still needs to be addressed, obviously. Next slide, please. And we have these 2 helplines, which are initiatives launched by our Department of Community Development. On your left, we have the Welfare Helpline, or Talian Kebajikan 141. This is operated by the Community Development Department, and they respond quickly to cases of abuse, neglect, persons in need of protection, child who is facing exploitation, in need of counseling, and any other family-related issues. And they have a separate line for children who can call up the Community Development Department, which is called Talian Anak 121. It's a free helpline. It's dedicated to children. It offers confidential counseling for issues ranging from bullying, drug misuse, self-harming thoughts, and family difficulties. It is operated by trained counselors, and it connects children to emergency services when necessary. So these measures demonstrate that Brunei's commitment to protecting not only the rights, but also the voices of its most vulnerable. In conclusion, Our court practices ensure that children understand the process and that their voices are heard. Our guardianship framework and welfare services provide additional layers of protection, and our helplines and public initiatives show real commitment to safeguarding children beyond the courtroom. What lies ahead, we see, is an opportunity. By continuing to strengthen legal aid, investing in specialized training, and raising awareness among families and communities, we can build on these foundations. We can make our child-sensitive justice system not only a protective shield, but also a guiding hand that helps young people find their way back into society with dignity and hope. In this sense, we would like to say that Brunei is not starting from scratch. We are moving from strength to strength, and with continued collaboration that we hope to have provided by meetings such as this, both nationally and within ASEAN, we are confident that we will ensure every child who encounters the justice system finds not only fairness, but also compassion and care. I thank you very much for your attention.
Thank you, Ms. Raihan, for your comprehensive explanation of Brunei's initiatives in this area. Next, we have our fourth speaker. Allow me to introduce Madam Le Thi Kim Ngok. She is an officer of the Department of Legal Dissemination, Education and Legal Aid Ministry of Justice. She had served as an officer in the National Legal Aid Agency, Ministry of Justice, from June 2023 until March 2025. She is also a holder of Masters of Law. Now, let us give a warm welcome to Madam Le Thi Kim Ngok.
Good morning, distinguished guests, delegates, and ladies and gentlemen. It's our great honor for the Department of Legal Dissemination, Education and Legal Aid of Vietnam, Ministry of Justice, Vietnam, to be here today. Thank you so much for your invitation. Our presentation today is about the innovations in legal aid for children, the experience of Vietnam. It's divided into three parts. The first one, I will give you an overview about the legal aid system in Vietnam. The second part is about the legal aid for children in Vietnam. And the last one, we will share some initiatives of Vietnam in legal aid for children activities. First slide. Next slide, please. Legal aid in Vietnam has been established and developed since 1997. On 20 June 2006, the 10th National Assembly promulgated the law on legal aid, marking a new stage in the development of legal aid activities. To meet the country's development needs, on June 2015, the Prime Minister issued the scheme on legal aid reform for the period 2015-2025, shifting the focus towards the substantive handling of legal aid cases, improving the quality of services, and strengthening communication to ensure that people are aware and able to access legal aid services. In 2017, the 14th National Assembly at its third session adopted the law on legal aid 2017. One of its key objectives is to enhance service quality, placing legal aid beneficiaries at the center. Legal aid means the provision of pro bono legal services to legal aid beneficiaries in legal aid cases and matters in accordance with the law on legal aid, contributing to guaranteeing human and citizen rights of access to justice and equality before law. To that, the legal framework on legal aid has comprehensively regulated issues relating to the organization and operation of legal aid, and provisions on legal aid have been incorporated into related codes and laws, such as the Criminal Procedure Code, Civil Procedure Code, Law on Administrative Procedures, Law on Custody and Detention, Law on Children, Law on Persons with Disabilities, Law on Domestic Violation. violence prevention and control, law on juvenile justice. The provisions of the law on legal aid and its implementing regulations also contribute to domesticating Vietnam's international commitments, such as the Convention on the Rights of the Child, the International Convention on Civil and Political Rights, the Convention on the Rights of Persons with Disabilities. In addition, legal aid has been incorporated into 5 national target programs, such as sustainable poverty reduction, new rural development, socio-economic development in ethnic minority and mountainous areas, drug prevention and control until 2030, and cultural development for the period 2025-2035. Regarding the legal aid system in Vietnam, next slide, please. The Ministry of Justice is the focal agency to assist the government in state management of legal aid nationwide. At the local level, the Provincial People's Committee performs state management of legal aid within the locality. The Department of Justice is the advisory body to assist the Provincial People's Committee in performing this task. And the State Legal Aid Center is the public service unit under the Department of Justice, with local status, its own seal and account. Organizations signing legal aid contracts with provincial legal justice departments and organizations registering to participate in legal aid provision are also legal aid organizations in Vietnam. Regarding the legal aid providing persons, they are legal aid officers, lawyers providing legal aid under contracts signed with state legal aid centers, and lawyers providing legal aid as assigned by organizations participating in legal aid provision, legal counselors with at least 2 years experience in legal consulting in organizations participating in legal aid provision, and the last one is legal aid collaborators. Now we will talk about the legal aid for children in Vietnam. Children are a group of special concern for both government agencies and social organizations. Legal aid not only helps children address legal difficulties and specific cases, but also enhances their legal awareness, thereby equipping them and their families with knowledge to prevent violations of their life, dignity, and health. Regarding the eligibility, under the 2017 law on legal aid, all children are entitled to legal aid regardless of gender, ethnicity, financial status, or guardianship. According to the 2016 law on children in Vietnam, a child is defined as a person under 16 years old. To protect the rights of those aged from 16 to 18, the 2017 law on legal aid added the provisions granting eligibility to accused persons aged from 16 to 18, financial disadvantaged victims aged from 16 to 15 in criminal cases. Other groups of minors under 18, such as ethnic minority, children in socio-economically disadvantaged areas, near poor accused, Agent organ victims, HIV-infected or disabled children with financial hardship, victims of domestic violence, and victims of human trafficking are also entitled to receive free legal services. Children receive free services in the form of, next slide please, legal consulting, participation in proceedings, and representation outside proceedings in civil, criminal, and administrative matters, except commercial cases. About the procedure for legal aid, of providing legal aid for children. Next slide. There are no separate procedure exists in providing legal aid for children in Vietnam, but the legal aid providers have to take into account the age, psychology, gender sensitivity, health, and family background, and help to comply with the provision of 2017 online legal aid and related documents when providing legal aid for children in Vietnam. About the statistics of legal aid for children, from January 2024 to May 2025, 9,385 cases for children have been carried out in the form of legal consulting, participation in legal proceedings, representation beyond legal proceedings. Many involve sensitive, high-profile cases such as sexual abuse or violence are also recognized in the court judgments. In the next part, we will share some initiatives of Vietnam in providing legal aid for children. The first one, the one-stop model, is developed with multidisciplinary support at hospitals and social centers like Ho Chi Minh City, Quảng Ninh Province, Lạng Sơn Province, combining healthcare, psychological, social, and legal aid services for abused and violated children. The number 2 initiative is 24/7 hotline, call center 111. It's managed by the Department of Maternal and Child Health under the Ministry of Health Vietnam, providing emergency support, basic legal service, and psychological assistance. In case of detecting acts of abuse, children can call this hotline to receive basic legal advice, psychological support. The number 3 initiative is interagency coordination. Regulations and cooperation programs between Ministry of Justice and the Supreme People's Court, Supreme People's Procuracy, Ministry of Public Security, Ministry of National Defense, Ministry of Finance, and the Vietnam Bar Federation are built to ensure legal aid presence in courts and criminal investigations. Number 4 initiative is child-friendly legal aid model. It's developed with UNDP and UNICEF support, ensuring it appropriate language, friendly settings, privacy protection, and trauma-sensitive approaches. The main features of this model are legal aid providers and relevant agencies, youth-friendly, easy-to-understand language, a ring-appropriate working space with children to reduce stress, support progress, connect multi-sectors like police, prosecutors, courts, health, and social work to ensure that children receive immediate support when they call the hotline 111. And the last one is applying information technology, digital transformation, reforming administrative procedures in legal aid. We are moving towards online case management, digital legal services, and data sharing platforms. To end our presentation today, we will share some recommendations for further reform in legal aid for children in Vietnam. Number 1, continue refining policies for coherence and accessibility to facilitate legal aid beneficiaries, and children is not an exception. Number 2, strengthen case handling for children, especially litigation. Number 3, enhance capacity of legal aid providers through training, ethics, and professional skills with focus on child-related cases. Number 4, promote coordination between legal aid organizations and related agencies, particularly in early detection of cases. Establish rapid response mechanisms for child abuse and domestic violence cases. Improve state management and quality assessment of legal aid for children. Strengthen social supervision, including the Vietnam Fatherland Front, media, and social organizations. And help to ensure adequate infrastructure and facilities tailored to children, accessible to office, child-friendly spaces, equipment. Last but not least, expand bilateral and multilateral cooperation, knowledge sharing, and resource mobilization to improve effectiveness. That's all about our presentation from the Department of Legal Dissemination, Education, and Legal Aid. Thanks for your attention. Thank you so much.
Thank you very much, Madam Ngoc, for that enlightening presentation. Finally, we have, last but not least, a very charismatic thorn amongst the beautiful roses that we have today, Mr. Cancio Xavier. Currently, Mr. Cancio is the Public Defender General of Timor-Leste since 2018. Previously, Mr. Cancio has served as a public defender since 2000 during the United Nations Transition Administration in East Timor, or UNTAD. Mr. Cancio had participated in several international conferences relating to access to justice, human rights, as well as alternative dispute resolution. He had obtained a degree of law in 1998 from the Satya Wacana University, Central Java, Indonesia. Now, with great honor, we would like to invite Mr. Cancio. The floor is yours.
Thank you for the time. And then thank you for distinguished guests and then delegate from member of ASEAN to participate for this convention. I'm briefly to thank to organizing committee for this convention. This stage is very prestigious to me, the first time in this place. I will thank to organizing committee and as well as of some technical support from Malaysian committee organizer, Mr. Atika and Ms. Fauzi. I'm not specialist for IT, so I'm not to design my slide likely of the IT professional. But I would like to express my gratitude to this convention, and then to invite me to represent my country to make presentation in regard of legal aid or public defender office. I think public defender and legal aid is not very far, but maybe closely the different kinds of representation. Next. Sometimes everybody asks to me, where is the East Timor? And then which one the location of the East Timor? I think Timor-Leste is under of Portuguese colony during 4.5 centuries. And then under of Indonesia regime 24 years. And then we get our independence on 20 May of 2002 under of recognized of international community. And then our population, I have to briefly to introduce to all of guests and delegate. The population of East Timor on June 2005, Timor-Leste have 1,480,517 according of the date June of 2025. Public defender is stabilized under of United Nations Transitional Administration in East Timor on 2000, and then have to transmit it to the national East Timor National Public Administration. And then for this occasion, we have 38 professional, 33 male, and then 5 male. For this delegation, for my delegation from Timor-Leste, I have one female, the professional female, and then she is being focal point for children, women, and disabilities. I hope that Mrs. Marcia to stand up. Thank you. Next, please. Timor-Leste adopted of civil law judicial system. In according of in the world, we have two big legal system, civil law and then common law system. East Timor adopted of a civil law system, and then even public defender office to be stabilized, especially at the common law system. But in according of transitional administration in East Timor, under of lead of Mr. Sergio de Vieira de Melo, he is originally from Brazil. He has vision to stabilize this institution because the Timor-Leste get independence on 2009. We still have alongside of the poor people. Geographically, we still have a problem about how to stabilize every local administrative, and then how to make the people access for justice. And then these circumstances may be very awareness to stabilize this institution to get assistance, and then to give in assistance for all the people. The principle of the public defender in East Timor, public defender office or the public defender agents is a professional, and then under of Minister of Justice previously, but for this year we get our autonomy, financial autonomy, and then administrative, and then legal autonomy. So we consider public defender office is a new one in the Asia. We will going to be full member of ASEAN on to 26th of October for this year. Even all of the member of ASEAN to assign Timor-Leste to be a member of ASEAN. Every circumstances in regarding of legal system, and then administrative system is also to be adopted by all the members of ASEAN. We, on the activities of public defender office, in according of civil, criminal, and then administrative code. I think very briefly, I indicated of Mr. Helmi presentation. I think very strongly spirit to my institution, how to adopt it. Even the Sharia system is a very kindful, how to formulate it and then to adopt it in my institution. I think very helpful, because this convention in the relations of children right. So every children in alongside of countries, they have right to get very, very careful assistance to protect them their right, and then in order of a legal proceeding and then civil proceeding. Next, please. In accordance of a legal framework securing access to justice, in Article of 26 of our national constitution, first is that everyone is guaranteed access to court of defending their legal protected right and then interest. The second, justice cannot be denied to insufficient economic means. The status of legal aid act, special of applicant guidance of a decree law 21st, the decree law O 2023, 12 of April. Statute of Public Defender to be regularity to right and the obligation of public defender agents. Law related of a court proceeding as well as of a criminal procedure court, civil, and then the status of judicial magistrate, and then the status of a public prosecutor. Mainly this status is mentioned to be professional deontology. Because the public defender office, we work under of this regulation, we work for freely without any honorary payment for every people, as well as of children right to be protected well. Next, please. This is, I mentioned before. Next. Next, please. Civil legal aid, representation of the court proceeding. In accordance of the public defender office, we work under of the civil procedure code. We protected of the children right in accordance of to protect them for abandon of family life, and then to receive any kinds of assistance, legal assistance, as well as of protection for the right. And then system of the registration office, we namely of SIGAS, Sistema Informatica Assistance Juridica. This is to register all the kinds of process in relations of children access for justice. Next, please. This case just demonstrated public defender office highly representation of in the country. So civil and then criminal and then in the remaining of the cases like to this slide. Next, please. Like I mentioned before about the criminal cases where legal aid or public defender agents will be aid services unavailable. Next, please. Special program for people in social vulnerability. These circumstances will be very carefully take care by public defender office. Especially we standpoint some especially professional to attending of this like I mentioned Mrs. Marcia to be assist of these circumstances. Next, please. Please, next please. Next please. Public Defender Office, we aware to assist the national residents and then international, some of the foreigner, even they come to Timor-Leste. They have conflicted of legal conflict. Public defender will aware to assist them without any payment. Next, please. Next, please. This, I just to mention about the branch of a public defender office. Then the central office centralized in capital of Dili, Timor-Leste, and then we expanded for 5 municipality. First is the Baucau, and Suai, Okusi, Bobanaru, and Ermera. Next, please. We also, for free legal consultation, this is a principle of the Public Defender Office, according of the dentology circumstances, we have to make consultation or given assistance, legal assistance for every people freely. Next, please. Next, please. Public Defender Office funded by budget, national budget, annual budget. So, Public Defender Office as a official institution and then under control of the government. I think this is my presentation, and to be aware of the delegation have any question, I will be aware to respond. Thank you.
Thank you, Mr. Cansio, for those insightful remarks on the evolving landscape of child legal aid in Timor-Leste. Thank you all to 5 engaging panelists for your rich and thought-provoking perspectives. Now that we have heard from all our distinguished speakers, I would like to open the floor for questions from the audience. If you have a question, please raise your hand. I will call upon you, and please state your name and organization, and kindly keep your question brief and directed to a specific speaker if possible. I open the floor. It seems that I have the first question here. This is directed to any of the speakers. What is the biggest challenge in your country in ensuring effective legal aid for children in both civil and criminal proceedings? Yes, Mr. Cansio.
Thank you for the question. I think where I'm saying East Timor is a new country, and then we have a challenge, big challenge, in according of less of human resources, and then lack of budget, and then the geographical circumstances is very very seriously circumstances to be assist the children right well. In according of International Convention for Children Right, we still not have a national framework to stabilize clearly in relation to protection of the children right. Because the children, they're very weak. And then even this morning, last night, Mrs. Azarina said that children right is have to protect it and then secure their right. But even though we have commitment for all of us how to protect them right, and then how to stabilize the national legal framework to protect themselves, to protect their right, and then to protect themselves from the abandon and then from the exploration circumstances. Thank you.
Thank you for your input, Mr. Kansio. I see that Ms. Sadana is eager holding the mic. Yes, carry on.
Hi, can you hear me? Okay, so I just wanted to add just two major challenges in my view, and I'm happy for Madam Sharina to add to this from the Singapore perspective. The first major challenge, I think, is we're very quick to create laws and safety nets for the children, but I sometimes see it's actually very difficult for it to translate to practice. For example, there are a lot of laws protecting children, but in order to access these laws, they may need a guardian, and some of these children may not have the guardians necessary to step forward. And so you just keep finding different people who can then step forward, or the court then appoints someone to help them to take out some of these, especially civil proceedings. So to me, the access is still, it's not as direct, it's not as clear, even though there's a safety net. The second, and I think this is more systemic of children who may not have the ability to advocate for themselves, is that there is no mechanism to raise some of these issues, right? There's a lot of the services available to adults, for example, for legal aid. It's actually very difficult for them to reach out sometimes to come and talk to us at our clinics. It is intimidating for children. So the challenges are twofold. One is in terms of being able to access the service, and the second is in being able to advocate for themselves, which is why I find the hotline 111 and the Talian Anak 121 very interesting, in the sense that it allows them to just pick up the phone and get direct access without having to go through a guardian. So my question actually would have been, for the two speakers who talked about it, how useful are these hotlines, and how do you encourage children to speak up for themselves? If we have time, I think this would be a question I'd have for both of them. Would you like to add to it?
Excellent, Ms. Adana. Yes, I see a beautiful young lady at the back. Please come forward. Just hold on. Mr. Kansio has a point to add. After Mr. Kansio has done, perhaps the young lady over there can come forward again.
I would like to add some important thing. I think why we have to establish the national legal framework, because according of the legal principle, every circumstances and then every situation in relations of the children, we have to protect them in according of legal framework. So that consists we have to pay attention in relations of this convention. Thank you.
Thank you, Mr. Kansio. Splendid. Can we have the young lady again? Please state your name and organization and direct the question. Thank you.
Thank you so much, Mr. Moderator. All right, my name is Aidatul Azra binti Zainal Abidin. I am the Director of Legal Aid Department Johor Baru, and I am one of the Secretariat here. So I would like to have this golden opportunity to ask a question to Madam Raihan. Okay, so I have learned that in Brunei, it covered when it relates to case involving the children. The law in Brunei cover limited only to capital offense, is it? So can Puan elaborate what is meant by capital offense in your country? That is all my questions. Thank you so much.
Capital offenses are the ones where the punishment is death. So that's what I mean by capital offenses. So when I say that we haven't had any children charged with a capital offense, that's probably something to celebrate, not something to commiserate about. So we haven't had any children charged either with a capital offense, and I don't even think we've had them charged with a high court case. We very rarely even have trials involving juveniles. So how the welfare system looks at dealing with children is the court is the last resort. They will look at all other resources that we have first. We have something called a Beyond Parental Control Order. Does Singapore have this as well? Yeah. So it's colloquially called a BPC order. Basically, if a child is just acting out, parents not able to keep them in check anymore, they can call up the Community Development Department and say, can you bring my child to court? Can you have the court deal with my child? And this is something that's dealt with a lot by the subordinates court, by the magistrates. So the court will then give orders that the child has to abide by. And oftentimes, what this results in is the child is either under some kind of supervision by a probation officer, or they're kept in our safety home, which is what we call complex rumah kebajikan. So that, I think, beyond answers the question, but I thought I would just also share that one of the reasons why we don't have that many cases, because the court really is the last resort when we look at dealing with children. We focus on rehabilitation, retraining them, and looking at fixing family dynamics. Because I think in Brunei, that is the main contributing factor to children who do misbehave. It's a breakdown in family relationship. Thank you very much for the question.
Yes. The distinguished gentleman over there, your question, please.
I'm Prem from Pro Bono SG. I'm actually just following up on Saad's question. I'm quite keen to know for Madam Raihan how the hotlines have been working. The two that you shared earlier, like what is the receptiveness from the children that have been using it, and is it something that has been, has it actually borne out some fruits? What's the experience been like on Brunei's side?
So I wish that we had someone from our community development department attending, because I think they would be the best person to answer the question, but I will try my best to still answer the question. The Talian Anak was launched much later compared to the Talian 141. So the reason that Talian Anak was launched is because they see that these children, a lot of them, the problems are coming in from schools. They talk to their friends in school, they talk to their educators in school. So we're not receiving calls from them on the Talian Kebajikan because they're not making these calls. They don't either are not heard by their parents, or either they just don't know how to make those calls. So when I was prosecuting, a lot of the time the cases are actually not reported by the victims. They're reported by the teachers. And the teachers don't even usually hear them straight from the victims. They hear them from a victim's friend. So the school is seen as the main place that receives information about children that are dealing with something difficult, either at home or in the school. So they launched the hotline. I'm not able to give you the numbers, but from my last conversation with officers from the Community Development Department and the Women and Children Abuse Investigation Unit, both departments that I work very closely with when I was prosecuting, because my portfolio was sexual offenses and domestic violence. They said they do receive some calls from the children, probably not as much as they would hope, but I think every little helps. So it's well worth keeping the hotline going, and hopefully with more of the talks that they're doing in schools, it's going to gain traction and they're going to receive a lot more calls. Thank you.
Is there any more questions from the floor? Okay, here's one from me. Finally, looking ahead, what reforms or innovations do you consider most crucial to improve access to justice for children. So each of you, please keep it brief. Give your best input. Perhaps we can start with Madam Sharina.
Your question, if I hear it correctly, was what is the best innovation for legal aid for children? Was that your question?
Yeah, moving forward, what are the crucial reforms or innovations that you might want to introduce to improve access to justice for children?
Okay, thank you very much for that very challenging question. So actually, I think this ties out quite nicely with your earlier question or question from the audience about the challenge of providing legal aid for children, where the children may be involved in court proceedings. And I'll give a very broad response, which is that to understand actually what the children's needs are today, they live in a very different time and world from where we grew up from. I was just reading a book on the anxious generation, and it gave me some indication that actually perhaps the biggest challenge and therefore the biggest need for reform might be in the area where we can reach them directly through the means of their generation's communication, which is digital media and all the other ways in which they communicate with one another and receive information from one another, whether it's good or bad. Unfortunately, now we're seeing a lot more negative influences. So how do we infiltrate actually that platform and into their thinking so that we build a generation that is resilient for the future? That's all. Thank you.
Yes, perhaps Ms. Sadana can add on from the Singapore experience.
Sure, I'll add on also from the perspective of a criminal defense lawyer. I feel no child is beyond redemption, and no child should have to beg for help or to be a subject of their circumstances. As a country, we need to empower our children with the ability to rehabilitate successfully, and that means we empower them with social workers, we empower them with psychiatrists, psychologists, and we throw everything we have at our children because they are the next generation and they will carry the country forward. In order to do that, we need to look at rehabilitation a bit differently. In my perspective, I feel that rehabilitation within the community is always best for children, and I'm sure there are some serious offenses that we may think, hey, maybe this child needs to be put away and reformed differently, but I take a very different perspective. I feel every child who is in the system, it's a cry for help, and it's a society that has failed them. So this means empowering the child with information, with help, medical help, psychiatric help, and it also means empowering the parent with help, because a lot of children who find themselves in this system come from families that are also struggling. And this is something I raise all the time, that the parents that sometimes do this, either through abuse or through not being neglect, not taking care of the children, for example, they themselves are victims in their own rights because they are also caught in some kind of generational violence or generational poverty, for example. Not all, surely, but most. And we must take the time to understand the circumstances that the parents are in and empower them as well, because only when the family unit is stable can the children also rise up and be stable contributors to society themselves. So my wish is for us to take a much more rehabilitative perspective, much more supportive perspective, and for the community to throw in the resources to help them, the family as a whole, as opposed to treating them as one monolithic unit. Either it's this sentence or this sentence, and then everything just seems to be a formula.
Super. Any thoughts, Ms. Raihan?
Yes, I think for Brunei, we really need to add on more training. Because like Madam Sadana said, there's really no use in having more laws if you're not going to be able to put the laws into practice. And from looking into our laws, we have provided for a lot of circumstances, but they're not put into practice because the officers dealing with them might not have the niche training that's needed for it. So I think across the board for the judiciary, the prosecutors, the social workers, they just need a lot more training. And the difficulty with Brunei is we have to really go out a lot to have those trainings because we don't have a lot of trainings locally in Brunei. But we hope to have a lot more. And if we have the training, then we can go out and help people in a better way that addresses their needs. Thank you.
How about Madam Ngok? Do you have any thoughts on this?
I will talk about interagency coordination, the regulations and cooperations between the Ministry of Justice Vietnam and the Supreme Peaceful Court, Supreme People Procuracy, Ministry of National Defense, Ministry of Public Security, Ministry of Finance, and the Vietnam Bar Association to ensure that children receive immediate legal aid in courts and criminal investigations. And also, we also receive so many support from the government and own organizations in Vietnam. Thank you so much.
All right, excellent. And finally, we have Mr. Kansio. Any thoughts?
I don't go so far because in relations of legal reform, it's very fundamental circumstances to be awareness. Why I'm saying the circumstances is very fundamental because in according of this legal framework as well as of in national legal framework and then the regional legal framework and then political awareness how to stabilize this legal framework to protect to take care about of children right, especially for judicial professional. Just have especially to handle, especially for children cases or children on the conflict of legal conflict, and then as well as of public prosecutor in our system, especially for public prosecutors also, they have to specifically to handle, to assist the children circumstances, even the conflicts of the legal circumstances, as well as of our institutional circumstances also. We have to stabilize, specifically professional under of one special section to handle specifically for children right. And then the political awareness, especially for in the region, to be established one standard legal framework to obey by the members of ASEAN. Thank you.
Thank you. Let's give a round, warm applause to all the speakers. Distinguished speakers, participants, ladies and gentlemen, we have had a truly meaningful session today. We have seen that while each of our countries faces unique challenges, there is a shared commitment across ASEAN to ensure that no child is denied access to justice because of their circumstances. There is wisdom in the saying, it takes a village to raise a child. Across ASEAN, we are that village, a big village. In fact, a very, very huge regional village, working together to ensure that children are nurtured, protected, and empowered through justice systems that serve them. And if I may borrow from Frank Sinatra's famous words in his song, My Way, this is about finding the ASEAN way, our own path, by our own cultures, our values, and our shared determination as exemplified by the speakers to protect every child. On behalf of the organizers, I would like to extend my deepest gratitude to our speakers, Madam Sharina Abdul Salam, Ms. Sadana Rai, Ms. Raihan Ghazali, Madam Le T. Kim Ngok, and Mr. Kansio Xavier, for their invaluable contributions and for sharing their country experiences with us. Let us continue to strengthen collaboration across ASEAN share best practices and build child-sensitive legal aid systems that protect and uphold the dignity of every child. No child is left behind. Thank you very much, and I wish you all a productive continuation of this convention.
So please, there's our moderator and speakers. Let's have a group photo.
Trapped in legal troubles, burdened by high legal fees, not knowing where to turn. The Legal Aid Department is ready to assist by providing legal services, representing clients in court proceedings, covering criminal matters, civil family matters, and Sharia family matters. Mediation services, legal companion services for child victims of sexual crimes. Bridging the distance, extending care to those in need.
Whether you're dealing with a divorce, civil lawsuit, estate matters, or other civil legal proceedings, navigating the legal procedures on your own can be challenging. Do you know that the Legal Aid Bureau can provide legal advice and legal aid, such as draft legal documents and represent an applicant in civil legal proceedings for those who are eligible? My name is Lawful, and let me tell you about the application process for legal aid and assistance at the Legal Aid Bureau, also known as LAB. To qualify for legal aid at LAB, you must be a Singapore citizen or permanent resident. You also have to pass the means and merits tests. The means test assesses your financial circumstances based on the following criteria. 1. Per capita gross monthly household income must be $1,050 or lower for the past 12 months. 2. Annual value of your place of residence must be $21,000 or lower. And 3. Savings and non-CPF investments must be $10,000 or less for applicants aged below 60 years old, or $40,000 or less for applicants aged 60 and above. In addition, you must not own any property other than your place of residence. The merits test assesses whether you have reasonable grounds for bringing or defending a case in court. Legal matters may not be easy, but help is available.
For Pro Bono SG, as a legal aid charity that enables access to justice, our role is to deploy full-time lawyers, full-time center manager, in order to deliver the legal services and to coordinate and mobilize our volunteers as well. And our role is to do that to help the community.
Average day of a center manager, we will attend to usually the walk-in applicants and see what kind of issues that they have and see whether issues that they have are suitable for consult or triaging to other legal aid schemes.
The rule of law is a fundamental pillar of our society. A criminal justice system that upholds the rule of law ensures that justice is accessible to all. To increase access to justice for vulnerable members of society, the government will be institutionalising public defence within our criminal justice system. With the formation of the Public Defender's Office, full-time public defenders employed by the Ministry of Law can provide legal representation to eligible Singapore citizens and permanent residents who are charged with non-capital criminal offences but cannot afford legal representation. With integrity, service and excellence, we will serve the public with dependability and trust. With justice, passion and determination, we will pursue justice in a fair and compassionate manner. The scales of justice symbolise truth and fairness, while the opening doors signify access to justice regardless of means. This is the Public Defender's Office.
The Public Attorney's Office, or PAO, is the principal law office of the Philippine government in extending free legal assistance to indigent persons and other mandated clients in criminal, civil, labor, administrative, and other quasi-judicial cases. By virtue of Republic Act 9406 that was approved in March 23, 2007, PAO has become an independent and autonomous office attached to the Department of Justice only for purposes of policy and program coordination. Compared to one which is under departmental supervision and control or administrative supervision, an attached agency has a larger measure of independence from the department to which it is attached. Aside from its central office, which has support staff and services, such as the executive support staff, the administrative service, financial planning and management service, special and appealed cases service, legal research service, and field operations and statistics service, the Public Attorney's Office has 17 regional offices, 361 district and sub-district offices, 2 regional special and appealed cases unit, and 1 satellite office. These offices are strategically located nationwide and where the PAO fulfills its mandate through its 2,681 lawyers and 1,034 non-lawyer personnel. At the helm of the Public Attorney's Office is its Chief Public Attorney. Being its nationwide head, she serves as the agency's Chief Executive Officer. Dr. Persida Viruweda Acosta DSD-JD is the current and longest-serving Chief Public Attorney of the Republic of the Philippines. She has been serving the PAO in this capacity since February 23, 2001. Dr. Acosta, the 4th placer in the 1989 Philippine Bar Examinations and multi-awarded public servant, has a rank that is equivalent to a department secretary. In view of her being the recipient of the highest presidential award for outstanding public service in 2004, or of being a Lingkod Bayan awardee that year. The PAO's commitment to genuine public service and fair administration of justice has always been reflected in its accomplishments. In 2024, PAO handled 847,317 cases and served 15,069,235 clients. Behind these statistical figures are real women and men with names and faces. To them, the Public Attorney's Office is honored and grateful to be of service. Likewise, in 2024, PAO attained an 83.63% favorable disposition rate for its cases, commendably surpassing the 83.5% target set under the General Appropriations Act of Fiscal Year 2024. Children in conflict with the law, CICL, are a significant, if not the most significant part of the 2025 Asean Convention on Legal Aid for Children in Malaysia. The CICL, the topic in being the main beneficiaries of this convention, belong to the mandated clients of the Public Attorney's Office as provided by Republic Act number 9344 or the Juvenile Justice and Welfare Act of 2006 of the Philippines as amended. In 2024, PAO was able to serve 18,925 children in conflict with the law and will continue in carrying out its advocacy for CICL. The Public Attorney's Office, an ISO-certified agency since 2018, obtained the highest ratings among the institutions and legal professionals in the Philippine justice sector, conducted by the Social Weather Station in 2021. The said survey was commissioned by Governance in Justice, a justice reform program funded by the European Union, with the Philippine government as its partner. In the SWS survey, PAO garnered 57% trust rating, making it the top institution in the Philippine justice sector. And PAO lawyers with 58% trust rating came out as the most trustworthy professionals therein. Recently, these recognitions have been bestowed to PAO. Outstanding rating in the justice sector as per the Department of Budget and Management's Fiscal Year 2024 Annual Agency Performance Review. And again, an outstanding rating for being one of the Philippine government's top-performing agencies in the 2024 Agency Performance Review conducted also by the Department of Budget and Management. Out of 308 agencies assessed by the DBM, only 14 received an outstanding rating, and PAO was one of them. It is indeed another feather in PAO's cap, a feather that will grow gentle but strong wings to carry PAO into greater heights of public service and administration of justice.
Ministro Administração Estatal Miguel Pereira de Carvalho Hateteng, lei eleitoral nebe Parlamento Nacional aprova, no haruka ona ba Presidente República, mas betohin loron sidau promulga, também está zero eleições tem que usa opção rua, ida lei eleitoral resistente, no ida fali lei eleitoral nebe foi na laisne Parlamento aprova. Mas bem hira alteração lei eleitoral né, Presidente República la promulga, está se usa lei tuang, no ne cidadão hotu se vota e harai moris fating inclui cidadão nebe e estrangeiro.
Proposta alteração lei eleitoral parlamento.
Antes né, Parlamento Nacional aprova alteração proposta lei número 50/5 Alteração Lei número 6/2006, loron Ruanulo Resinwalu, fulan dezembro, eleição parlamentar e a final global. Alteração lei ne atufobiba ba eleitor sira, tanto iha rai larang no rai liur, no mos cria condição nebe adequado ba ema ho deficiência matang, ho de hasai litan tasa participação iha eleição parlamentar nebe se halau, iha loron Ruanulo Resingida, fulang maio tinane. Celina Lopes, Agostinho da Costa, GMN.
Right, there you are, ladies and gentlemen. Thank you very much. Just before we break for our lunch, this is a special announcement. We would like to invite our delegates and guests to take your time to explore our exhibition booth and visit the Justice on Wheels, the JOW mobile van, a flagship initiative by the Legal Aid Department Malaysia that brings legal services directly to remote and underserved communities across Malaysia. So, ladies and gentlemen, the JOW, or the Justice on Wheels, is more than just a van. It's a moving symbol of justice, offering legal consultation, education, and support to those who need it the most. So it reflects our commitment to ensuring that those far are reached, those near are cared for. And while you are there, stand a chance to bring home some exciting goodies from our exhibitors. So ladies and gentlemen, please enjoy your lunch. We will reconvene at 2:30 p.m. So please be back in time as we continue with the next segment of our program. With that, thank you very much. Enjoy your lunch.